tour.
Sorry about that. You could go ahead.
Okay. So part 2 of our cross-examination kind of clinic is that we're on impeachment this evening. So the way Kyla and I kind of thought about it to ourselves is there's really 2 types of impeachment. You could have a situation where obviously you're impeaching a witness on a sex assault about previous statements, but the lesser known or lesser used by defense, particularly area of impeachment, is when you have to impeach your own witness. Excuse me, I shouldn't be drinking Pepsi while I'm doing this. Okay, so we're going to start with impeaching your own witness, if that's okay for everybody. And I think it's important to point out that in knowing how to handle this law, if you ever need to impeach your own witness, you're also preparing yourself for situations where you have to respond. So where the Crown, so I just had to sneeze, where the Crown has a witness who isn't saying what they want them to say and they have to impeach. And for example, I mean, if you're impeaching your own witness, that's something, but if the Crown is trying to impeach a major witness on a murder case that now says your guy didn't do it, you want to come up with have some handy tricks next to you to come up with ideas about how you might want to try to keep that evidence out. So I think it kind of impeaching your own witness has the dual play of preparing you to impeach your own, as well as knowing how to handle when the Crown is trying to impeach their own. Because in my experience, they do it quite often. And there are ways for us to overcome that. I mean, we all know that sometimes witnesses disappoint us, whether they're witnesses for the Crown or they're witnesses for the defense. And it's unfortunate that thinking about all those sex assault trials we do, and it'd be nice if we could impeach our own witnesses sometimes and cross-examine them and suggest to them all of the things that we want them to say. Unfortunately, it doesn't work that way. So anytime that you're looking to impeach a witness, your own, or the Crown is attempting to impeach their own, the first step, of course, is going to be a review of the decision of Milgard. We're all familiar with it. I think all of us were exposed to it in law school. And it is the leading case in dealing with this, the first step in your process, because there's a multitude of steps that you go through. So the first step is you're attempting to refresh the witness's memory, and that's with reference to Section 9.2 of the Canada Evidence Act. I always found it kind of funny that when they wrote the sections of the Canada Evidence Act, they didn't go 9.1, it goes 9.1, 9.2, but you actually use 9.2 first, then you go to 9.1, then you go to the common law. It always just seemed to me that they were a little bit out of order. So go to Milgard and think about what you're trying to do. What's the purpose? Are you attempting to refresh the witness's memory? If that's what you're trying to do, then it's a simple application under 9.2. Hi, Your Honor, the witness has said, and you have to be direct. He said A, B, C, D, E, and F, but when I interviewed him shortly after the incident, as an eyewitness that maybe the police didn't interview, he said H, I, J, K, L, and M. And you have to have a voir dire and point to those specific differences because it is still your own witness. And you never want to, or the court doesn't want to be seeming like you're impeaching the credibility of your own witness. So 9.2 is your first stage. It's prior inconsistent statement. Then, if that's not successful, and you want to have the witness declared adverse. So let's say you're able to cross-examine the witness, like, I never said that, or I was pressured to say those things, or I've changed my mind, this is my memory now. And maybe your girlfriend's or your client's girlfriend was on side a year ago, but she's now not on side of the trial because they've broken up and she's trying to send your guy to jail. Then you might want a finding that she is adverse in interest. And it's not adverse in the sense that she's for one side or the other, but she's adverse in the interest of the case and she's trying to hold that evidence hostage. If you are granted and you are allowed to cross-examine your own witness under Section 9.1, again, it's about inconsistencies, but it also has to be within the parameters of what's relevant to the case, meaning, location, observations, things of that nature. You can't go outside of that. And you can't go outside of it because, again, it's still your own witness. And because there's an inherent level of credibility or reliability or trustworthiness in that witness when you choose to call them. I'm calling this witness here's their evidence, and you're never allowed to really go after their credibility at large. If you are able to, and if this is the third step, if you are able to have some evidence, call some evidence to determine that the witness is hostile, you're now out of the Canada Evidence Act, and you want to use the common law, which is a hostile witness application. Not only would you then be entitled to cross-examine at large on the elements of the offense or the incidents touching on the issues at trial, you're actually also now allowed to, with the court's permission, attack the credibility of the witness. I had this come up on a biker case I did last year. My client's father, also a member of the bike gang, ended up having his charges withdrawn because he was dying of cancer. He has some evidence to offer. No, so the Crown bringing the application, but the Crown brings the application. There's inconsistencies. Obviously, he doesn't want to see my client, his son, convicted. And we went through all of these processes, first trying to refresh memory, then adverse witness, and then ultimately a hostile witness application. If you are dealing with needing to deal with 9-1 or 9-2, all of the discretionary tests, so everything you kind of need to know and the steps that you need to go through are outlined in those sections of the Canada Evidence Act. So that's the first place you want to go to. But it's also important to bear in mind that whether or not you're allowed to do this at any of those three stages, it's completely within the discretion of the trial judge, meaning they have to look at it and weigh and assess, are the ends of justice best met by allowing the 9-2, the 9-1, or the hostile witness? And this always comes back to this idea of a witness holding evidence or holding information hostage. The ends of justice are not best served if a witness is holding on to information. It diminishes the truth-seeking function of a trial. If there's very similar cases, I'm more focused on Ontario, but there are similar cases. I know of one in Manitoba. But if this is an issue that's coming up and you're practicing in Ontario, of course, you want to look to the Carpenter decision. It's Carpenter number 2. And I can give you the citation. It's 1982, OJ number 129. It's kind of paragraph 13 and onwards. And that's a decision of the Ontario Court of Appeal. If I'm not mistaken, BC and Alberta and Quebec have all cited Carpenter with authority. So I guess that would be adopted. Manitoba, as best I could see, did not adopt it. So if you are practicing in Manitoba, there's two cases that you want to look to. One is CLS, just the acronym CLS, which is a 2011 decision of the Manitoba Court of Appeal. And that's MJ number 8. And you also want to look to Aikenhead, AIKENHEAD, Manitoba judgment as well, Court of Appeal, 2001 MJ number 187. And really the main thing, there's a list, there's things you can think of. There's really every case out there has come up with some ideas as to when the discretion should be issued or when it shouldn't. There's a lot of academic articles out there that summarize it quite well. I found a really good one that was actually written by my local Defense Counsel Association at a conference we did back in 2015. It's on Canley, and I'm happy to share it to the WiCCD email, and maybe we could send it out afterwards. It breaks it down really nicely and gives lots of those instances where the discretion may be granted or may not be. But we have to also keep in mind that it's really two themes, whether it's the Crown bringing this application and you're trying to oppose it, or you're bringing the application and your Crown's trying to oppose it. It's really issues of 1, trial fairness, and 2, reliability. So much like when we go through a Kellowan type application or any type of hearsay application, you're looking to those inherent indicia of reliability. Is the previous statement reduced to writing? Was it recorded? Was the witness under oath? Was it a spontaneous utterance said in the moment? Things of that nature. That can help you in assessing and telling your trial judge, here's why you should grant me the discretion, trial fairness to the accused, and then secondarily, here's why this evidence in the form that I have it is really, really reliable. Unfortunately, like most things in criminal defense work, I find an issue comes up and we are expected to jump through a multitude of hurdles to get over these tiers. But if an issue with respect to needing to impeach either the character as a whole or contradict the witness that you've had no option but to call, there's a lot of case law out there that is really helpful and it can be done. You're going to have to go 9-2, 9-1, and then perhaps a common law hostile application. But I double down on them. If this is something that is really important to my client's defense, it is what it is. You know, you take the time, you pause, you enter the voir dire, you get case law, and you make sure that your judge doesn't screw it up, particularly if they are a new judge and not really on top of the law. Never let, and I find this happens a lot more with junior counsel, but don't let the court's desire for efficiency and getting things done to derail you. Make sure you take the proper steps that you need to, and to satisfy yourself that you've done all of your due diligence. I haven't done this in a while, but the other thing that struck me, ladies, was that, I don't know if you guys have the same experience, but for a period of time, about 5 to 10 years ago, I bring a charter application on a drugs case, and the Crown would insist that it not be blended. I had to argue the charter at the outset. And they're like, oh, by the way, I'm not calling the police witnesses. You know, the police witnesses who you're saying breached their charter rights, you know, maybe unlawfully searched your client, stepped on his ankle, whatever they did. Now you have to call them as a witness and attempt to lead them in a direct examination when you know that their position is diametrically opposed to yours. And it's not really, I guess it is, would be cross-examining your own witness, but you wouldn't necessarily even have to resort to 9-1. I've brought an application at the outset of the charter application, setting out the Crown's ridiculous position and why it can't be blended, and that seek leave to cross-examine the police officers. I didn't have time before logging on to kind of find a case on point, but I know I've argued it several times. And if anyone is interested, feel free to email me. I'm sure I could find the case over the weekend, and I'll get them to you. I'm not finding that drug prosecutions, the Crowns, are doing this as much anymore, so maybe they've gotten off the trend. But I know for a period of time, I was having a lot of difficulty with that. And I've never not been granted the application to cross-examine my own witness when it's the police officer that I'm alleging made a number of charter violations. So I'm not sure if Kyla is here yet, but that's kind of all I wanted to say, or I think that I had to offer tonight in the time that we have on cross-examining your own witness or impeaching your own witness.
Hi, I'm here.
Yay! So I covered the first part, Kyla. I did the impeaching your own witness.
Perfect. All right. Well, I just actually wanted to follow up because I've been here for a while and I heard
good.
I was only 7 minutes late. You should have seen me running out of the courthouse. Like a box, a bag. It was all good. I did want to follow up really quickly on impeachment and where the witness is not situation, because there's a really interesting case that came out of the Quebec Court of Appeal recently, and unfortunately it is all in French. So it'll only be helpful to you if you could get a translation, or if alternatively you know French well enough to rely on the case. But it's about cross-examination on a prior inconsistent statement and interrupting in progress testimony in order to call a witness in order to prove that an earlier statement had been made. So, you know, and that could be either way, where the person, you know, you say, you know, you told the police this and they deny making that statement, and then you need to interrupt the evidence and allow a witness to be called to prove that the statement was made. You are entitled to do that when you're in cross-examination. And if a judge doesn't allow that, it could amount to an error. In the case that this concerns, the MH case, although the court said that could be an error, it didn't actually amount to an error in that case, because the accused called the witness, the police officer witness, as part of their own case. So just also remember, like, another way sort of around this is to call like if you want to prove that somebody made a statement, make sure you call the person that they made the statement to, in order to sort of lay the foundation for that. So the citation for that, for those who love French, is 2023 QCCA 645. So just what you were saying reminded me of that. So
Oh, that's it's a great case, Kyla. I didn't know about that. And could you just say the citation again?
yeah, it's 2023
Mhm.
QCCA 645.
Perfect. My partner is French, and I think he's got a translation test coming up.
Perfect. I just rely on what people who speak French tell me as well, so it's good. Okay, so I think that Natasha said like as much as I could possibly say as well about dealing with your, impeaching your own witnesses. I don't, in my experience, it doesn't happen that often that you have to do it. Certainly not in the types of cases I deal with. Usually I'm not about to put my client on the stand and then impeach them going, I wasn't drunk, I only had 2 beers. So it's not going to come up a lot. But you should know how to do it. But I thought starting at the Evidence Act is a good segue, because I do have another PowerPoint where I'm going to talk about sections 10 and 11 of the Canada Evidence Act and how they relate to impeachment. So I'm just going to share my screen here. Oh, look at, I have no screen sharing. You guys don't have to suffer through my PowerPoint today. Okay.
I'll share the hosting duties, Kyla, if you like.
Oh,
Yeah.
great. Sure. Although I always get, I can just speak. I can send the PowerPoint out afterwards too. It's not a big deal. Yeah.
Not a problem.
Okay, perfect. So I have a good quote, like I started last time with a good quote from James Wigmore, who writes about impeachment by saying, in a very male-centric way, we place his contradictory statements side by side, and as both cannot be correct, we realize that in at least one of the two, he must have spoken erroneously. Thus, we have detected him in one specific error, from which may be inferred a capacity to make other errors, which is really just a wordy Wigmore way of saying, if you catch someone saying 2 contradictory things, it probably means they're contradicting themselves on other occasions, or that they're mistaken on other occasions. So at its core, impeachment is presenting a witness with prior statements or information that demonstrates that their evidence is not consistent or not credible. So Section 10 of the Canada Evidence Act talks about cross-examination of previous statements that a witness has made in writing. So cross-examination as to anything that's been reduced to writing, recorded in some way, so recording, a video recording that's relevant to the subject matter of the case. And Section 10 sub 1 of the Canada Evidence Act says that without the writing being shown to the witness, or the witness being given the opportunity to listen to it or watch the video or anything like that, or otherwise take cognizance of the statements. But so you can cross-examine on it without showing them. But if you intend to do so for the purposes of contradicting the witness, then you have to put it to them before you can say that they are contradictory. They have to be, their attention has to be brought to the parts of the statement that are to be used for the purpose of contradicting the witness. And also, the third part that I don't like is that the judge can say, okay, now I get to see a copy of this. So the judge at any time during the trial may require the production of the writing or tape or other medium for inspection, and thereupon may make such use of it for the purposes of the trial as the judge thinks fit. Which, to me, is a big problem, which is why you want to try and do your impeachment if you can, often without having to put the state to the person, which is where your preparation is coming in. You basically want to get them to agree to what's in the statement without having them say something that's contradictory to the statement and having to go to the statement. I've never had a case where a judge has said, well, you're impeaching the witness based on this, so hand it up, I want to see it. And then they get, other information that they can use however they see fit. I've never had that happen, but the risk of it is terrifying. And we think of impeachment as this tool that gives us a lot of power in cross-examination. But if we're impeaching with prior statements that have been put in writing or put in a recording, it actually creates a situation of vulnerability that you need to be able to respond to. So that's section 10 of the Canada Evidence Act. And the section 10, well, that's section 10 sub 1 of the Canada Evidence Act. Section 10 sub 2 talks about a deposition in a criminal investigation, which we never deal with. Section 11 deals with the cross-examination of witnesses on prior statements that were made by them, but ones that you have a recording of. It says, where a witness on cross-examination as to a former statement may be made by him relative to the subject matter of the case and inconsistent with present testimony, does not distinctly admit that he did make the statement, proof may be given that he did in fact make it, but before that proof can be given, the circumstances of the supposed statement sufficient to designate the particular occasion shall be mentioned to the witness, and he shall be asked whether or not he did make that statement. So if you have, for example, a police officer saying that they were told by a paramedic that they didn't smell liquor on the breath. And then the paramedic comes to court and the paramedic says, oh yeah, I totally remember this. I one of the most horrific accidents I ever saw. And it sticks out in my mind because I smelled liquor on his breath. Then you have to put to that witness, before you try and impeach them with what the police officer said, you gave a statement to the police officer at the scene. You recall giving the statement. You told the police officer that you did not smell liquor on the breath. Is that right? Did you make that statement? And then if they disagree, then you can impeach them by calling the police officer witness to say, no, that's what he told me. So that's not a direct impeachment, but sort of a roundabout impeachment where you're using a different witness to impeach your witness, but make sure that you always confront them with it. And really what these two sections of the Canada Evidence Act are effectively like a codification of an aspect of the rule in Brown and Dunn, right? We all know that if you're going to cross-examine somebody on contradictory evidence, or if you're going to call contradictory evidence later, you have to present it to the witness to get their comment on it. That includes obviously impeachment, but also contradiction through other witnesses or your own witness. You have to give the witness the opportunity to respond. And this, of course, only matters to things that are of substance and not things that are largely inconsequential. So when we get into the obligation, when we're doing impeachment, especially through our own witnesses and through witnesses that we're calling as part of our case, if we go back to those rules in the Canada Evidence Act, which are essentially this codification of this common law rule, we see that it's the subject relative to the subject matter of the case. And arguably, like if you mess up, if you forget to put something to a witness and then you want to contradict it through your own witness or through another witness later, if it's not related to like an essential element of the offense, you can say, well, the Canada Evidence Act only requires me to do this where it relates to the subject matter of the case. And this portion of the witness's testimony, that doesn't go to the subject matter of the case. And so it doesn't matter as much. And you may get away with it, you may not. So what happens if you forget to put something to the witness that you intend to impeach through another witness? Like essentially, what are the remedies in these circumstances? Obviously, you need to try your best to recall the witness. The court can grant a ton of remedies if you fail to sort of set up the impeachment that you're going to do through a later witness. And the remedies can be significant as against your client. So the court can say, I'm going to take into account the failure to challenge that witness in the assessment of credibility, essentially saying I'm going to take your witnesses and reduce their credibility because you didn't confront. I'm going to grant leave to call witnesses in reply to the evidence that was not put to the witness in cross-examination, or I'm not going to allow you to call this contradictory evidence. That last one was used in a BC Court of Appeal case, but it was really dated. It was like from the 1970s or something. So it's probably, and it's extreme. That's the extreme remedy, where the judge is just going to say, you didn't ask about it earlier, so I'm not going to let you ask about it now to try and impeach that witness who didn't have the opportunity to respond to it. Canada Evidence Act also says you have to do it this way, so don't think you're getting away with something sneaky here, counsel. And that's probably not going to happen, but you do need to seek leave if you realize you messed up as soon as you know that you've inadvertently breached the rule, or as soon as you suspect that you may have inadvertently breached the rule. You have to make the application to recall the witness if you're intending to bring some evidence later for the purposes of impeachment. A lot of people and it's terrible to be in the position where you're in court and you're like, oh crap, I forgot to ask the witness this. I messed up. But you're in a worse position if you don't make the application, and then you're just in the court's hands for whatever remedy they grant and whatever credibility determination they're going to make, than if you say, inadvertently, Your Honor, I failed to ask this question. I need to put this to the witness because I intend to impeach them later on through the evidence of my client, and I didn't do that. So may I please recall this witness before I continue with my case, or before I call my case, or as soon as like literally stand up in the middle of some cross-examination and shout it out if you think that you've messed it up, because you're not going to get an ineffective assistance of not likely to get an ineffective assistance of counsel if you right away say that you inadvertently failed to do it. Whereas if you do nothing about it and then you're like, yeah, I messed up and now my client's in a worse position, the fact that you didn't try and fix it, especially because there's pretty broad leave to let a witness be recalled, especially for a limited purpose. So that is also something you should keep in mind, that if you fail to set up your impeachment through the witness that you're going to impeach with your own evidence later on, you can fix it. So don't worry, ask to fix it. And the judge is probably more going to be in an error if they don't let you fix it, because you're the defense and you're supposed to you're supposed to get as fair a shake as possible. And it wouldn't be right to let evidence go unchallenged that may be exculpatory, right? Like that's how you characterize it to the judge, and they'll be more scared of the appeal than they will be of anything else. Natasha, did you intend to talk a little bit about the impeachment formula?
I had a few comments I wanted to make on the stuff that you raised. Is that okay?
Yes, and then I have some on impeachment formula, so I'll let you go first and then we'll, yeah.
Perfect. So just on the, it was a good refresher. Thanks for that, Kyla, about section 10 and section 11. We forget about those sometimes. But what I typically do in my practice is I did this sex assault trial last week and this week, and obviously it's mostly a he said, she said. But when I started my cross-examination, confronting her about, in this case, for example, she went to the police twice before, she gave a statement, and then she comes to the court. And when she comes to court, the first time she's saying there's safety concerns for her and the children. So I pulled out the investigative actions of the officers, which I also called as part of my case, to say, no safety concerns, right? You said this. But before I even got to that place, I set out at the beginning who she spoke to and when, and that she was being truthful. Like I said last time, it was a serious investigation. You weren't holding anything back. You knew you could correct it if you needed to. And never once did you say to any of these people that you were concerned for your safety. Never once did you say to these people you ever concerned for your children's safety. On occasion, usually the Crown will step up and say, well, if she's going to impeach her on a prior statement, she needs to put that statement to her. My Crown this week and last didn't, because he's more experienced. And I always say, no, get the witness out of the room. Say, no, this is cross-examination. She can agree or disagree with me. But if she says she doesn't remember, then I'm happy to put the statement to her. In my case, there are a lot of other, which goes into 11 as well. Like, you've got to prove those statements. There's a lot of other golden nuggets in those officers' notes about what she said and didn't say. So I did call both those police officers as part of my case, which is weird, having to qualify notes and doing all of that. But it was important because it was important for my client. Just on that note, about Brown and Dunn, and it has to relate to the subject matter of the case. What Crowns sometimes forget is they also have to give you notice. I mean, we're not perfect. I've certainly messed up before and said, oh my gosh, I forgot to ask this. Can we please bring the witness back? We all do it. So don't beat yourself up. It happens. But what's worse is that if it happens, or the Crown is alleging that you failed a rule in Brown and Dunn, they have to tell you that they take a position before everything's said and done. They can't just stand up in submissions and say, she breached the rule in Brown and Dunn. And I'm expecting that it might happen to me tomorrow, because as it happens when clients testify, God help us, I wish we could cross-examine them. But of course, the version he gave me before was a little bit different than what he said on the stand. Unfortunately, particularly about a couple of important points, and I tried to fix it in re-examination, but there's some more collateral things that I didn't touch and I didn't fix, because in my view, and even though I cross-examined her on them, it doesn't matter, because it really wasn't the subject matter of the case. It was about what happened the next day and who said what and things like that. So if he tries to pull that out, I've got Brown and Dunn in my back pocket tomorrow, because unfortunately I don't have I have a civil judge on a sex assault trial in Superior Court. So the factum that I ended up writing is about 102 paragraphs just of law, because I'm afraid that she's not going to get it. So never a bad thing to just say that you've messed up, but remember what the obligations are. And if the Crown springs on you in the last minute, you have a good argument. We can get an adjournment. Okay, Your Honor, we'll come back and we'll do closing another day and we'll get this witness back and we'll do all of those things. But, you know, if there's I always say too, if there's a failing here, that's on me. That's not on Mr. X. I'm the one that missed that, right? I'm the one that missed that. That's on me, and it wasn't related to the case. So, and then you kind of fall on the sword, and no judge is ever going to make a finding as against you, especially when you beg forgiveness. And yeah, I'm not perfect. So I just wanted to follow up on those few points, Kyla, on what you were saying. If you want to start with the impeaching other witnesses.
Okay, so I thought I'd give a little like very basic level overview of the classic impeachment formula, which is if the evidence you want from the witness has been like recorded or reduced to writing or some sort of, you know, form that you can put to the witness, then you're going to want to seek to refresh their memory about what they said using their prior recollection recorded. Some people will take, there's sort of two different schools of thought on this. Some people take the approach of, you know, first confirming that either they don't remember or confirming the thing that they want to impeach, and then handing them the document, asking them to silently read their whole statement to themselves or like a significant portion of it before asking the question again. Whereas other people, my method is to just direct them to like the exact point you want, which is where your preparation is going to come in that we talked about last time. You're, you know, being well prepared and having all the things that you intend to impeach on lined up with multiple copies. You're going to pull out one and you're going to have the highlighting on it for what you intend to impeach on. And you're going to put that to the witness and just ask them to read the highlighted part silently to themselves and then ask them about it. And that I find to be more effective because it is essentially not going to refresh the witness's memory about other things that are in the statement that maybe you want them to refresh their memory on. Probably you don't want them to refresh their memory on all the really bad things they said that they forgot about when it came time for court. So I like to just like do something that's going to direct their eye or their attention to only one bit, confirm that they said that. And I've never gotten in trouble for it. So it's gotta work. The other thing about that is if you are very specific to, because I had a Crown do this to me once, if you're very specific to with the witness about what you are putting to the witness for the purposes of impeachment, it also boxes the Crown in a lot on their redirect. Because I once just asked about a whole form where they check off a bunch of symptoms and the importance of that form, et cetera, you know, and tried to impeach the witness on a symptom that he'd invented for trial, only to have the crowd stand up and go, well, that document Miss Lee put to you, can you look at that again? Okay, and you also checked off slurred speech. You didn't mention slurred speech before, so you did see slurred speech. Okay, and the Crown like got away with that as redirect. So I don't like to give them the chance. Like I give them, you know, this much that they might be able to redirect on after I'm done with my impeachment. So the common method of impeachment follows 3 simple steps. So it's easy, 1, 2, 3. get the witness to commit to the new version of events, validate the prior statement by addressing the circumstantial reliability of that statement, and then confront the witness with the prior version of events. I say the downside to this is that it doesn't permit you to put the motive behind the impeachment to the witness, nor does it specifically require the witness to adopt the earlier statement, right? You want them to adopt the earlier statement because you're impeaching them because it's helpful to you. And you also want to get out that there would be a motive to either fabricate now or a motive to have been telling the truth then. So like I said earlier, you're going to want to question the witness first without going to the statement about the statement. And I try to question them on it first and then only bring the statement to their attention if they don't readily agree. I would also say, don't just jump at every opportunity for impeachment. Some lawyers think, oh, if I can impeach on anything, it's better to do it on everything. Oh, I'm going to get to how I see a question in the chat. How would I alter the approach? Read the checklist. I will get to that. So I don't impeach on everything if it's not necessarily going to help you. And this is because there's a rule that people often forget, which is the collateral fact rule. So if a witness testifies about a collateral fact on cross-examination, you're stuck with that. And then you can't file evidence as part of your case to contradict it. So you don't want to end up trying to do impeachment on something that doesn't matter. That's a collateral fact, getting the witness to blurt this collateral fact out, not going the way you want, and then your impeachment has failed on something that was pointless, and you've ended up actually making things worse, and you can't call evidence to contradict it. So don't do that. I also say my way of altering the approach is essentially by doing it a slightly longer, but slightly better in my very humble opinion way. So in addition to validating the statement that you put to the witness, I say ask the witness about the reasons why the statement was accurate and truthful. Explain the reasons why the statement is also more likely to be true. So one thing that I often do is I'll ask them about things that would make both of these things true, not just that they knew that they should tell the truth, like they were intending to tell the truth at the time, but also if they were mistaken, why their recollection of events was better at the time. I mean, you can probably see where the easiest way to go with this is your criminal trials taking place 6, 8, 10, 12, 14 months later or longer. And your witness is not necessarily going to remember it as clearly. So I will ask them as I'm setting up the prior statement, not just that you gave a statement to the police and you knew the statement could be used in court and it was important to tell the truth, but also, this incident happened 20 months ago and you've talked about it a lot with your friends. Not every day you see a serious car accident. It's not every day that somebody holds up a bank while you're in it, right? Like this incident was important enough to you that you needed to talk about it. I even had a witness once where I went through his 6 months of counseling that he took afterwards. What are the other things I wrote down here? That they've been thinking about the incident a lot when they've been in similar locations, in a bank robbery, right? You've been to a bank since, and it brings back memories of this to you. And so you think about it a lot. And sometimes as you think about things, it can distort it in your mind. The statement you gave, it was fresh in your mind. You knew it was important. You knew it could be used in court. The police officers were there. You knew, and all of those things. So not just why it's more likely to be true, but also why they were motivated to tell the truth at the time and why their memory was better at the time. So it's a minor change and it takes longer, but it tends to focus on the likelihood of the earlier statement being true as opposed to why it's more inherently reliable. And then once you've established both the circumstantial reliability of the statement and why it's more likely to be true, then you can get into the impeachment. And the benefit of this is if you do it for a whole statement and there's maybe 10 or 15 points you want to impeach on, you only have to set it up once, and then you can just go back to the statement. And if you train your witness well and you have a lot to impeach on, as soon as you say, well, you said in your statement to police, they will back down. It's so funny how people like just resile from their positions once they've been beat up a couple times. Like they will just start to back down. Well, okay, yeah, if I said it there, then it must be true. Of course, you have to follow up on that. Like that's not enough. That's not a good enough answer, but it is. It is. Sorry, I read the comments and got distracted in my brain. It's, you know, it's getting them to give up on what they've said in court, and then, you know, you have them. Don't get this approach twisted. The last thing you want to do is get the witness to read the statement first and then ask them about the reliability of the earlier statement. Because in the time that they're sitting there and they're reading that and they're going, oh crap, I said something today that's not the same as what I said before. And then they start to get terrified if they're like a lay witness that they're going to get charged with perjury. And if they're not a lay witness, they're worried about a negative credibility finding on their career. You don't want to put them in a position where they can start to think of ways that why their earlier statement was wrong. Well, I was really traumatized at the time. And so, you know, when I was traumatized, I wasn't thinking clearly and I misspoke. Or yeah, there was a lot going on. There were police officers and firefighters and emergency services, and I was distracted and I said the wrong thing. Like, you don't want to give them the opportunity to justify why their earlier statement was incorrect. You want to confirm it was truthful first so that they can't back away from it. That's the only way you're going to successfully achieve the impeachment using the prior statement. So don't do it in the opposite way. But do make sure you spend the time, if you're going to be relying on that statement, and if it's important, spend the time doing not just circumstantial reliability, but why it's more likely to be true. So that's my alteration of the classic formula.
If I could just, it's like I'm just adding on. Like Kyla's covered a lot of the topics that I would have. Can everyone hear me okay? I can't see Kyla anymore. There's just a couple other things. Okay, good. Just want to make sure because I'm using my phone. My internet and my computer is still not cooperating. It wasn't a couple weeks ago either. So the other thing a couple of things I want to pick up on what Kyla said. I agree with everything that she said. Those are very much the same tactics that I use. Slight difference from my perspective is on the impeachment. So yes, you set it all up at the front, truthful. Here's why it's circumstantially reliable. Here are all the good things. I do. It's the first thing I ask the witness. So when I get down there a half an hour, an hour later, it's already quite clearly set up, right? Remember what you said to me earlier. You weren't lying. You were being untruthful. But Kyla said she highlights the passage, and then she has the witness review it herself. There's nothing wrong with doing it that way. I personally like the witness to find the line. Okay, could you find that line with me? Are you there? It starts with, and then he was next door, right? And then I read it to the witness. For context, officer says, and then what happened? You respond, and then he was at the door. And then what I do is I use we forget sometimes when we advocate with our voices, but our voice and our tone in itself is also an advocacy tool. And what I mean by that is when I am reading it and then questioning the witness about it, I can emphasize the words that are important that you did not say to anyone that you felt unsafe. So I have no safety concerns when dealing with Mr. X. And you emphasize those words. You're drawing the jury or the judge's attention to the fact that those are the important words. And then I go back and I ask questions. You'd agree with me, that's what you said, and they're kind of locked in and short, tight questions. They can't wiggle out of it. But I find that it's a way of kind of doing it twice to get the impact of it twice, and then you get to use your voice as an advocacy tool, which I find really helpful. On Kyla's point again about it's really tempting, especially when you're younger, you want to impeach on everything, right? Oh my goodness, like the sex assault. I'm sorry, it's sex assault, but that's where my brain is right now. It was sex assault, and she said in her statement that he used his right hand, and then she said in court that it was his left hand, and you're like, I'm going to impeach her on that because that's an important thing. Is it really? He inserted his fingers into her vagina. That's the takeaway. Is the judge going to find her less credible because she said right 3 years ago and she's saying left now? No. But the damage that you're going to do there is you're going to have to rehash all of that, the intricacies of what the alleged sex assault, because if maybe he's missing one arm, Could be, that would be good. But if you have to go through all of those things, and if you're like mine this week, my complainant was pretty consistent in the actual act of the alleged sex assault, that I'm highlighting that there's no inconsistencies with respect to that stuff. So if I just stay away from the whole sex assault, and then you just brown and done, or I'm going to put to you that this happened and this happened and this happened and this happened, much more powerful. But you have to stay away from those small inconsistencies and realize you're giving up a little something for a lot of gain, right? Because otherwise you're just highlighting to the judge that she's pretty consistent, and when she says that he did X, Y, and Z, right? Which we never want to do, because your client hits the box and testifies to a different version and cries because his former girlfriend is accusing him of rape, and then he comes across a little bit more believable. So that's what I wanted to say about that. I think you've covered everything else, Kyla. What time are, oh yeah, you have a few minutes for questions, I guess. I answered a couple in the chat while you were talking.